Imagine walking into the highest court in the world's most populous country.
Right.
Your personal freedom or, your business or even your life savings are on the line.
High stakes.
Exactly. And you suddenly realize the entity summarizing the evidence against you or the one drafting the legal memos, it isn't human.
Yeah, that's a wild thought.
It's a machine processing millions of pages in fractions of a second.
Which is just impossible for a human clerk.
Right. Today, we are exploring a staggering 57-clause blueprint that takes that whole sci-fi scenario and turns it into an imminent reality.
It really does.
We are taking a deep dive into the sweeping draft regulations for use of artificial intelligence in courts, which was recently released by the Supreme Court of India.
And to really understand the massive implications of this, we are unpacking a stack of incredibly detailed analytical sources today.
Yeah, some great material.
We have this really in-depth commentary from cyber law expert Vijaya Shankar now.
Who goes by Navi, right?
Right, widely known as Navi, over at Navi.org. And we're pairing that with comprehensive legal reporting from Legal Eagle Elite.
So good.
The mission here is to figure out exactly how a justice system built on, centuries of agonizingly deliberate human reasoning plans to govern the most rapidly accelerating technology on the planet.
And if you are listening right now, whether you are a tech developer building these algorithms or a legal professional trying to figure out if software is going to, take your job.
Which is real fear.
Oh, absolutely. Or even if you're just a curious citizen who wants to know how justice is going to be served in the future, you need to pay attention to this.
Yeah, you really do.
Because this isn't some vague memo about the future of tech. It's arguably one of the most comprehensive judicial AI governance frameworks ever proposed, anywhere in the world.
There, yeah.
It's a literal blueprint for how society is going to balance the unbelievable power of AI with the fundamental human right to fair justice.
And, what stands out immediately when you read through the source material is that this framework adopts a distinctly Indian approach to a global problem.
How do you mean?
Well, the Supreme Court is actively welcoming AI. They see it as a necessary, powerful assistant to the justice system.
Okay.
But they draw this hard, totally non-negotiable line. Artificial intelligence will absolutely never be used as a substitute for human reasoning.
Okay, let's unpack this. Before we even get into the nuts and bolts of what the software is actually allowed to do in a courtroom, we really need to understand the philosophical tightrope the Supreme Court is walking here.
Right, it's a delicate balance.
They are trying to balance radical technological progress with the protection of human rights. And they set the tone right out of the gate with Regulation 17.
Which is fascinating.
Yeah, establishing this principle called innovation over restraint.
I mean, that is a highly unusual posture for a judicial body to take.
Usually they're pretty conservative about this stuff, right?
Exactly. Historically, the law is entirely reactive. It waits for a new technology to arrive, it waits for it to break things or cause harm, and then, it tries to regulate the pieces after the fact.
Right, sweeping up the mess.
Yeah. But Regulation 17 actively creates a presumption in favor of responsible AI adoption.
Wow.
The court is formally stating that if an AI tool can reduce delays or improve administrative efficiency or just enhance access to justice, the system should adopt it.
They actually want this.
They are actively encouraging exploration rather than just, putting up roadblocks.
But they immediately pair that enthusiasm with this bedrock principle of human primacy.
Yes, that's crucial.
They make it crystal clear that the ultimate authority to determine matters of law, fact, and justice remains exclusively with a human judge.
Always.
It sounds like they're treating the AI like a brilliant, lightning-fast paralegal, but one who is strictly forbidden from ever approaching the bench to make a final call.
That paralegal analogy works perfectly here. I mean, the AI can fetch the documents, right?
Right.
It can summarize the historical precedents. It can translate the regional languages, but it cannot wield the gavel.
Right.
What's fascinating here is how the framework actively combats the black box nature of modern AI to enforce that human primacy.
A black box system being one where we don't really know how it thinks.
Exactly. It's a system where even the developers don't fully understand the specific mathematical pathways the AI took to arrive at a conclusion.
That's terrifying for a court.
It really is. You put data in, you get an answer out, and the middle is just a mystery.
Right.
So the Supreme Court is declaring that kind of opacity completely unacceptable in the justice system. The AI must meet incredibly high standards of explainability.
I think so.
The judicial officers, the lawyers, and the public, They all must be able to trace the logic behind any AI-generated output.
Yeah, because if you don't know how that brilliant digital paralegal came up with the answer, you have absolutely no foundation to trust the answer in a court of law.
Right. You can't cross-examine a black box.
Exactly. And if we follow that logic, what specific tasks is this digital paralegal actually permitted to do? Because Chapter 3 of these draft regulations lays out a very clear bifurcated rulebook.
Yeah, the framework splits everything into permitted uses and absolute prohibitions.
Okay, let's start with the permitted side.
So on the permitted side, under Regulation 19, we see a huge focus on administrative heavy lifting.
Like what?
We are talking about automated case management, finding procedural defects in new filings, and preparing daily cause lists.
Okay.
It also allows for automated transcription of court proceedings, which, I mean, when you think about the sheer volume of oral arguments, that is a massive operational shift.
Oh, I can imagine. But translation seems like the real game changer here, doesn't it?
Absolutely.
I mean, in a country like India, with 22 official languages and literally thousands of dialects, having an AI that can instantly translate complex legal vernacular from English to Tamil or Hindi without losing the judicial intent, that's monumental for public accessibility.
It's huge. And the permitted uses heavily target that kind of accessibility.
Yeah.
They cover legal research, precedent retrieval, document summarization, and services like text-to-speech or Braille translation for visually impaired litigants.
That's amazing.
It is. But even within these highly beneficial, completely permitted uses, there's a strict human-in-the-loop requirement.
Meaning a human has to double-check it.
Exactly.
Yeah.
A designated human officer always has to verify the accuracy of the machine's output.
Okay, so then we hit Regulation 20, the prohibited uses, and these are described as absolute and non-derogable.
Meaning zero exceptions.
None. No algorithmic decision-making for judgments.
Not at all.
You cannot use AI for risk scoring. So you can't use it to determine if someone gets bail or to predict recidivism or, to evaluate if a witness on the stand is credible.
Right.
And you absolutely cannot use it for behavioral profiling or surveillance of judges, lawyers, or litigants.
Yeah. So the court has basically built this incredibly strict, highly defensive fence around the core judicial function.
I have to push back on this a little bit, though. Let's look at flight risk, for example.
Okay.
If an AI can process 10,000 past cases in a matter of seconds and statistically analyze millions of complex data points about a suspect's background, wouldn't it technically be much better at predicting if a suspect is going to flee than, say, a tired human judge who has been hearing back-to-back cases for 9 hours straight?
That's a fair point.
Right. Like, why ban the math entirely?
It's a highly intuitive question.
Yeah.
If machines are better at math, why not let them calculate risk?
Exactly.
But if we look at how these machine learning systems actually work, the danger becomes glaringly obvious pretty fast.
How so?
AI models are trained on historical data, and historical human data is fundamentally flawed.
Because humans are flawed.
Right. When you use risk scoring tools to predict recidivism or flight risk, the AI basically acts as a pattern matching engine.
Okay.
And it often picks up on hidden historical proxies for race, class, religion, or caste.
Oh.
Yeah. It might look at a specific zip code or an employment history gap or just a neighborhood's arrest record and mathematically assign a high-risk score to someone from a marginalized community.
Just based on their zip code.
Exactly. It does this simply because, historically, people from that community were over-policed and arrested more often.
So the algorithm isn't actually being objective at all. It's just laundering historical human prejudice through a computer to make it look like objective math.
Precisely. And because these risk scoring models are incredibly complex, I mean, they're often proprietary black boxes with billions of parameters.
The defense attorney can't see how it works.
Exactly. The defense attorney can't cross-examine the algorithm to expose that underlying data bias.
That is terrifying.
So the absolute ban on these tools in matters of personal liberty is a deliberate safeguard against algorithmic prejudice.
I see.
The Supreme Court is taking the stance that when a person's freedom is at stake, they deserve to be judged by a human being who can actually exercise empathy, contextual understanding, and equity. Because those are concepts that literally cannot be coded into a statistical probability matrix.
That reframes the entire restriction for me. We keep the AI away from the final judgments and the risk scoring, and we restrict it strictly to research and drafting.
Right.
But treating the AI purely as a research assistant introduces an entirely different, highly technical danger.
Oh, yes, it does.
Let's talk about the danger of the AI simply making things up.
Yeah, the technical term is hallucination.
Right.
This is the phenomenon where a large language model generates outputs that seem incredibly plausible, legally coherent and perfectly formatted, but are entirely fabricated out of thin air.
And to understand why this is so dangerous, we have to look at how these models actually work. They aren't querying a secure database of hard facts.
No, not at all.
A large language model is essentially a predictive text engine on steroids. It is constantly guessing the next most mathematically probable word in a sequence. So if it knows a legal citation usually looks like State versus Smith, 1998, Volume 4, it will confidently generate a string of text that perfectly mimics that structure, even if that case never existed in the history of human jurisprudence.
Which is an absolute nightmare for legal precedent.
Right.
I mean, we have already seen the news stories globally of lawyers walking into courtrooms and citing fabricated case law because they trusted a chatbot.
Oh, yeah, those stories are everywhere.
Under this new framework, if a lawyer or a litigant uses AI to prepare evidence or pleadings, they have to formally disclose it to the court at the time of submission.
They have to declare it.
Yeah, the draft includes specific formats, annexure, top, and data, just for this declaration.
And the framework is totally ruthless about the consequences of hallucination.
Very ruthless.
Regulation 8 makes it explicitly clear. If you submit AI-generated material that is false, fabricated, or misleading, you are fully accountable. It is essentially the ultimate "the dog ate my homework" excuse. Except the dog is a massive neural network, and the Supreme Court is saying they absolutely will not entertain it as a legal defense.
Right. The mandatory governance process ensures the final decision-making authority and responsibility always rests with the human filer.
You can't pass the buck to the AI.
No. It forces legal professionals to rigorously verify every single citation and every single fact before they file it, putting a hard stop to AI hallucinations, poisoning the well of legal precedent.
Now, the Navi source material points out a staggering institutional response to this problem. They are proposing the creation of an AI content verification authority.
Yeah, this is perhaps one of the most ambitious and honestly potentially unwieldy parts of the draft.
Tell me about it.
The framework proposes a dedicated institutional authority charged solely with overseeing and continuously updating the verification standards for generative AI content used in the court process.
That sounds huge.
Navi points out the sheer scale of what this actually means.
Yeah.
To effectively police synthetic text at the national judicial level, you would essentially be required to set up a massive, highly specialized forensic tech lab.
And to do all this drafting, summarization, and transcription, and then forensic verification, the AI systems need to ingest an unbelievable amount of data.
Mountains of data.
Which puts this entire framework on a direct, high-speed collision course with India's brand new privacy laws.
Data privacy is the stickiest web in this entire draft.
Oh, for sure.
Chapter 7 of the regulations explicitly states that all AI systems deployed in the courts must comply with both the Information Technology Act of 2000 and the new Digital Personal Data Protection Act, or DPDPA, of 2023.
Here's where it gets really interesting. The framework creates a completely new category of data called sensitive judicial data.
Right.
This includes any personally identifiable information of parties, witnesses, or legal representatives, and it mandates strict data minimization and anonymization before a single byte of data can be used to train or refine an AI system.
Which sounds good on paper.
But wait, hold on, I'm lost. If a court issues a judgment, that record is generally public, right?
Usually, yes.
Anyone can walk into a courthouse or look up a published ruling online. Why is the Supreme Court suddenly guarding this data like it's classified state intelligence when it comes to training an AI?
So the distinction lies in the concept of data aggregation.
Okay.
A single public court record detailing, say, a property dispute is one thing. But when an AI ingests millions of records, traffic tickets, divorce filings, bankruptcy proceedings, civil suits.
It connects the dots.
Exactly. It gains the ability to cross-reference and profile individuals at a scale that completely shatters any illusion of privacy.
Wow.
It can draw inferences about a citizen's financial stability, behavioral patterns, and personal relationships that a human clerk could just never piece together.
That's intense.
It is. Now, under the new Privacy Act, the DPDPA, there isn't actually a specific definition for sensitive data.
Wait, really?
Yeah. The Act only defines a significant data fiduciary as an entity handling a large volume of sensitive personal data.
Okay.
Navi's analysis highlights a massive legal catch-22 here. If the courts formally declare all this judicial data as sensitive, the judicial authorities themselves automatically cross the threshold to become significant data fiduciaries under the national privacy law.
How does a court system processing its own administrative files suddenly become categorized as a significant data fiduciary alongside, multinational tech platforms and social media giants?
Simply by virtue of the sheer volume and the newly minted sensitive nature of the data they're feeding into these machine learning models.
That is wild.
And this classification would subject the courts to a massive amount of mandatory compliance, regular independent audits, data protection impact assessments, and potential liabilities under the Privacy Act.
That sounds like a nightmare.
It creates a paralyzing administrative overlap.
Which means the courts would be so bogged down in data privacy compliance that they wouldn't have the resources to actually innovate or deploy the AI tools they're trying to champion in the first place.
Right. And Na'vi suggests a specific legal maneuver to avoid this gridlock.
What's the fix?
He points out that the Ministry of Electronics and Information Technology, known as MAIDI, might actually need to formally exempt the court systems from certain provisions of the DPDPA.
Can they even do that?
Yeah, they could potentially do this under Section 17.2 of the Act, which deals with exemptions for instrumentalities of the state maintaining public order.
But even with an exemption from the National Privacy Act, the courts still have to adhere to the framework's own strict internal rules.
Very true.
They prohibit transferring sensitive judicial data to any external system without express written authorization. And the AI must also be audited for cybersecurity threats at least once a year.
Which naturally leads to the largest practical hurdle in the entire document.
Right, who is actually policing all of this? We have strict rules on data anonymization, absolute bans on risk scoring, mandatory disclosures for hallucinations, and forensic verification authorities. Who is the referee managing this sprawling system?
This brings us to the governance and bureaucracy section, which is where the Na'vi source material really delivers its sharpest critique.
Yeah, this part is wild.
The proposed oversight structure is undeniably massive. At the very top, there is a permanent, full-time apex body at the Supreme Court level.
A 9+ member committee, right?
Yes. Chaired by a Supreme Court judge, including other High Court Chief Justices, an official from MAIDI, cybersecurity experts, finance experts, and academics.
And it doesn't stop there.
No, it cascades down from there. This apex body has 5 dedicated subcommittees. They're proposing a Center of Research and Excellence on Artificial Intelligence, or POR AI, just to provide analytical and technical support. And then the structure physically decentralizes. The Supreme Court and every single high court across the country will be required to establish their own individual AI committees, supported by their own dedicated AI secretariats.
Navi's analysis raises a massive red flag regarding the sheer practical implementation of this structure.
It's a lot.
This highly decentralized approach means you have separate bureaucratic bodies making independent approvals, conducting duplicate audits, and managing isolated incident databases across wildly different jurisdictions.
Yep.
Navi estimates that staffing this entire national apparatus could require around 1,000 highly specialized individuals.
And the financial burden is equally staggering.
Yeah.
The operating cost for this administrative oversight is estimated at around 250 to 300 crore rupees annually.
Let's contextualize that scale for a second. We're talking about tens of millions of dollars a year just to pay for the bureaucracy overseeing the software,
Right.
with capital expenditures potentially exceeding another tens of millions of dollars just to build out the infrastructure.
It's a huge investment.
With 5 core, that's 50 million cases currently pending in Indian courts, is building a massive administrative AI bureaucracy really the best use of strained judicial resources?
That's a tough question.
Or will this just create a nightmare bottleneck where software vendors are waiting years to get their basic transcription tools approved by, 25 different high court committees?
If we connect this to the bigger picture of technological adoption, Navi argues there is a severe danger of overgovernance here.
I see that.
When you duplicate these highly technical functions at every high court, you inevitably invite conflicting decisions and standards.
Yeah, a brilliant legal research tool approved in Delhi might be rejected on a technicality in Karnataka.
Exactly, completely fracturing the justice system's technological baseline. So Navi proposes a much more streamlined solution.
Which is?
Centralize the oversight. Create one grand expert team, perhaps a consolidated committee of the Chief Justice's all high courts, to handle standard setting, software approvals, and impact assessments at a singular national level.
I mean, that makes sense. Build the engine once, perfect it, and deploy it everywhere, instead of asking every state to build their own regulatory engine from scratch.
Right.
Centralization would drastically reduce those multi-million-dollar costs, ensure uniform legal standards across the country, and prevent the whole system from collapsing under its own administrative weight.
Now, there's another fascinating, highly technical detail about these mandatory audits that feeds directly into this governance problem.
Oh.
The framework states that technical, legal, and ethical audits of the AI must be conducted every single year.
Okay.
But it explicitly mandates that these audits must be conducted purely in-house.
Wait, what?
Yeah. Under no circumstances can the source code, the underlying algorithms, or the training datasets be shared with any third-party or private entity outside the secure court premises.
Well, I mean, that sounds like a profound security measure. It physically protects that sensitive judicial data we talked about from leaking to private tech contractors.
It does.
But it creates a massive tension with the framework's own demands for transparency, doesn't it?
It creates a monumental technical paradox. Auditing an advanced AI isn't like auditing a financial spreadsheet where an accountant can clearly track a formula from cell A to cell B.
Right.
You're dealing with neural networks containing billions of weighted parameters. If you don't bring in specialized third-party technical experts who build these systems for a living, an in-house legal PIC team has virtually no way of deeply understanding what the algorithm is actually doing under the hood.
So what does this all mean?
Well,
If you step back and look at this 57-clause document, you are witnessing the Indian judiciary standing incredibly boldly into the future.
absolutely.
They aren't hiding from artificial intelligence. They are actively drafting the blueprint for how to tame it. They are demanding that AI remain a transparent, accountable assistant, a tireless, lightning-fast paralegal, rather than an autonomous judge. And the reason you should care about this, even if you never set foot inside a courtroom, is that this framework is setting a massive global regulatory benchmark.
How the world's largest democracy decides to balance the strict demand for human accountability with the staggering efficiency of machine learning is going to influence every other high-stakes industry on the planet.
Oh, for sure.
Healthcare, finance, human resources, they will all inevitably look to this judicial framework as a precedent for how to write their own rules of engagement with AI.
But that paradox regarding the audits leaves us with a lingering unresolved tension at the heart of this technological revolution.
It raises the ultimate question for the digital age, one that the framework hasn't fully reconciled.
Yeah.
Throughout the document, the regulations strictly ban opaque black box algorithms. They demand total explainability and absolute transparency to ensure fairness for every citizen.
Right.
But simultaneously, to protect privacy and data security, they mandate that all technical audits remain strictly in-house, legally forbidding independent outside experts from ever examining the code.
Wow.
How can a justice system truly build public trust and guarantee actual transparency if independent experts are fundamentally locked out of the room where the algorithm is being audited?
It's the paradox of the locked box. We demand to know exactly how the machine thinks, but we legally forbid anyone from looking inside to verify it.
It's a real puzzle.
It is a question that legal scholars, technologists, and citizens will be wrestling with long after these draft regulations become law. Something for you to mull over. Until next time, keep diving deep.